Hello, everyone. I'm Shahzeb Usman, and we welcome you to our conversation. Today, we will be discussing some of the issues within institutional frameworks of international criminal law. We're joined by Mary Lobo. Mary Lobo is a British lawyer who studied law at an undergraduate level from University of Oxford, United Kingdom, and then completed her LLM in international law at the University of Nottingham, United Kingdom, where she was awarded Best Graduating Master's Student. She also spent a year in Germany studying German civil law as an exchange student. She has co-authored a number of articles on state practice and international law and has a particular interest in the procedures of international legal institutions such as International Criminal Court. She's currently based in London, where she's working as a research analyst and plans to pursue doctoral studies in international criminal law. Hello, Mary. How are you? Hope it's not raining in London today.
Hi, Shahzeb. I'm well, thank you. Yeah, we've got sunshine. And thank you for inviting me to come on today. It's a great pleasure to be here.
Well, it's a pleasure to have you as well. Well, to start off, can you tell us what exactly evidentiary mechanisms mean in international criminal law and what mechanisms currently exist in the international criminal law?
Yeah, it's an interesting place to start. Obviously, when we think about international criminal law, the courts are kind of what you think of first, but the evidentiary mechanisms are sort of organizations that the UN has set up as non-judicial bodies to collect, preserve, and analyze evidence of international crimes in particular situations. So they're situation specific. And there are sort of three current mechanisms, although other human rights and investigatory bodies under the UN have some degree of power to collect evidence. So the three that currently exist, you've got the IIMM, the Independent Investigative Mechanism for Myanmar, which is looking at the events in northern Rakhine State and sort of the genocide there against the Rohingya people. And then there's the IIIM, helpfully named very similarly, the International Impartial and Independent Mechanism, which is for Syria and looks at crimes that have been committed since March of 2011.
Hmm.
And then there's UNITAD, which has a very long name, but
Oh,
is effectively an investigative team for crimes committed by ISIL, Daesh, as kind of some countries call it, in Iraq. And that was set up in tandem with the government in Iraq by the UN Security Council. The others were set up by different UN bodies. What's really interesting about the evidentiary mechanisms, though, is they're not just sort of a passive database, and they're also not the same as a fact-finding mission. So, for example, with Myanmar, we've got the IIMM, but there was also a fact-finding mission which was aimed at finding out the truth. The evidentiary mechanisms are aimed at eventually supporting prosecutions. So they don't just take information, leave it in kind of a box somewhere. They're strategizing, they're trying to find out where the gaps in evidence are. For instance, that is part of UNITAD's terms of reference, that it is to identify the places where kind of national prosecution can't find evidence and then target that, find the witnesses, find the physical evidence,
hmm.
collect it according to international standards, preserve it, put it in case files, and have it ready should a prosecution be brought later.
Perfect. I think that's wonderful to know. And I think this takes me to my next question. My second question relates to the intersection of international criminal law with the local legal system. So, to put it
Mm-hmm.
simply, how do you view the significance of the interaction of evidentiary mechanisms, which you just mentioned, within the national legal systems?
Yeah. Um, so for international criminal law in general, you can kind of see it at the international level with international bodies, but then realistically, it needs to come down to a national level as well. International courts and bodies don't have the capacity to kind of deal with everything awful that happens in the world, right? Um, so the evidentiary mechanisms, their interaction with legal systems varies between the mechanisms because they all have different terms of reference, different mandates, and different levels of cooperation, to be honest. So, as I was saying, UNITAD was set up with the government of the state in which the crimes being investigated were committed. So it's designed to facilitate domestic prosecution there, and it's fairly easy for it to do so within the limitations of the terms of reference because of that link. But for the IIMM, the Myanmar mechanism, the authorities there have been very reluctant to cooperate. So the significance of that mechanism's interaction with national legal systems is more for prosecution abroad under principles of universal jurisdiction, or, for example, if there were a national of a foreign country involved in an international crime in Myanmar. Generally, the way they're designed to operate is to provide evidence to national prosecuting systems. And for the IIIM, that has already happened. It's contributed to 36 proceedings in judicial systems already, according to their last report. So there is a slow kind of growth in that collaboration. 36 cases is not a lot if you consider how much evidence they are able to collect. But it's something on a practical level. The other significance, I think, is more theoretical, and that's about the decentralization of international criminal law. If you look at international criminal law as a central framework, then it operating on an international system makes it, or can make it, quite insensitive to the context of specific crimes, specific victims, specific perpetrators. By interacting with national legal systems and not just the international legal system, the evidentiary mechanisms can facilitate a decentralization of that and the ability of national legal systems to take into account their own cultural and factual contexts. So I think it really, it starts to help to grow out international criminal law into something that is both more practical and more nuanced in addressing the things it seeks to address.
Perfect. I think the input of the evidentiary mechanisms in the national prosecution is extremely crucial in solving such cases. I generally have, I do understand your point totally on that matter. My third question relates to the non-judicial body and how do they slot into the international criminal justice system. So is international criminal law just about international courts and treaties, or should the conception about it should be more broader, So do you think, should our conception be broader than that?
Yeah, I think there is definitely room for ICL to be broader than just international courts and treaties. The evidentiary mechanisms are one example of that, because they aren't judicial. They weren't set up by treaties. And although they are overseen by the UN, and in that way slot into kind of an international understanding of international criminal law, as we were saying, they operate predominantly at the moment on a national level, engaging with civil society and independent governments. But I think also, if you look at the formulation of the Rome Statute, the founding treaty of the International Criminal Court, and even going back to the Nuremberg trials in kind of after the Second World War, international criminal law has always been about more than just courts and treaties. It's intended to be about addressing atrocities, right? Addressing these awful things that happen. And although political agendas have been and possibly always will be kind of overlaid on top of that, there are many ways to address an atrocity. And trying to have a one-size-fits-all solution through just the institutions of courts and just the means of treaties is not going to do very much. I think there are plenty of criticisms that could be leveled at a narrow approach to international criminal law like that, not least that treaties operate at a state level. It's states talking to each other. Atrocities quite often happen within a state at a much lower level than that. So if you just focus on treaties, you will be excluding most of the stakeholders in what international criminal law should be doing. So one way in which I think international criminal law currently is broader than that is also through the national capacity building work of things like the Office of the Prosecutor at the ICC, that kind of is a way in which the ICC is more than a court in the normal sense. It's doing more than you'd expect, say, a domestic court to do by going out and training national prosecutors, national judges within individual systems. And that's allowing a lot broader of a sense of what international criminal law can do, because then those judges, those prosecutors can take that law and develop it in their own way, as I was saying, to fit their context. But on the other side of things, criminal law is criminal law. There are things that are necessary to be done to address atrocities that law is just not suited to do. It can be tempting to kind of go straight to law because we're lawyers. That's kind of our thing. But it's not politics, and it's not necessarily what will be required for community healing when something awful has happened. Sometimes other things have to step in as well. So I think, yes, ICL needs to be broader than just international courts and the treaties that tell us what the international crimes are. But there also shouldn't be this drive to make it heal all ills. It's not everything within the system.
I totally agree with you on this matter that, diluting the focus of international criminal law might just distract the main reasons of the creation of international criminal law. I think while non-judicial bodies should also play their part. Takes me to my fourth question, which is about the intersection of international criminal law with public international law. So I just wanted to ask you, how can the two impact each other or have an intersection with each other?
Yeah. So I think there are lots of ways in which the two interact. It's interesting because international criminal law is primarily focused on individuals. Public international law, in its classical conception, is primarily kind of to do with states. It's increasingly to do with individuals, and you can see overlap in other areas like human rights. But there's kind of that classical distinction between states and people. One way in which there's an overlap there, though, is where state responsibility for atrocities is being sought. So, for example, genocide cases being brought at the ICJ, the International Court of Justice, they're not seeking individual responsibility for a crime in the way that the International Criminal Court is, but they're seeking to then attribute those acts to a state. So we saw that classically with the events in the former Yugoslavia, where individuals were tried at the criminal tribunal for the former Yugoslavia, the ICTY. So the key issues in cases like that for public international law are state responsibility and attribution of acts, but it also relies on international criminal law in determining kind of what the relevant acts are and whether they were international crimes. Similarly, there's a case running at the moment under the Genocide Convention of the Gambia against Myanmar, which, although it relies on the Genocide Convention definition of genocide and not on any individual kind of international criminal law definition under, say, the Rome Statute, it's still using international criminal law principles to categorize that behavior so that it can be attributed to the state. The kind of other way in which PIL can interact with international criminal law that I think is really significant is sort of the inverse. What I've just been talking about is the application of international criminal law in public international law. There's also the application of public international law in international criminal law. So the clearest example, I think, here is procedural, and that's in immunity. Although the ICC has decided that immunity is not relevant when they issue arrest warrants under their jurisdiction. So, if they issue an arrest warrant against the leader of a state, the fact that that person is head of state is no obstacle to the arrest warrant as far as the ICC is concerned. Individual states don't always agree with them. So, for example, when the ICC issued an arrest warrant against the president of Sudan, al-Bashir, some states refuse to arrest him. They refuse to act on the arrest warrant because he's a sitting head of state. He has immunity, ratione personae, which is a concept under public international law. And I think that's where the significant overlap can come, because international criminal law relies on states, and states have other duties and other kind of considerations, even just within law. That's without thinking about politics and what's going to look good in front of the people and whether there's an election coming up. Just within law, they have conflicting obligations, or what they could perceive as conflicting obligations. So you get this interaction of public international law concepts applying to states and leaders of states that then have to interact with the procedure of international criminal law. And that's another really interesting way in which ICL is broader than just international courts and treaties, because it relies on state cooperation. And states don't exist in the sort of perfect ICL bubble in which the only thing they're ever going to do or think about is international criminal law. You get other things moving in, and ICL has to be able to accommodate that.
Yeah, I think the intersection of public international law with international criminal law is really interesting, especially how the two relate in the recent famous case of, Gambia versus Myanmar, where international criminal crimes were committed, but many public international law concepts also came into discussion. So I find that very fascinating. I think this leads me to my next question, Rich. And my next question is that it's often stated that the ICC should focus on leaders, not on prosecuting individuals. Do you think that the prosecution of high-level figures in the context of immunity and the need for state cooperation makes any sense?
I think in some ways, yes, and in some ways, no. So
Okay.
if you just look at it in the context of immunity, yes, it can make sense. Domestic courts and foreign courts do not have the power to prosecute high level figures, by which I mean kind of heads of states and some high ranking ministers. We kind of, you saw that in another case brought before the ICJ, the arrest warrant case, where kind of someone tried to arrest a sitting minister because of the gravity of the crimes he was accused of committing. And the ICJ ruled that you can't do that. Immunity exists, and it's not overruled by the severity of an offense.
Yeah.
So in kind of plugging that gap,
Yeah.
international courts, it would make sense, right, for them to focus on doing the things they can do that other courts can't. So they definitely shouldn't kind of rule it out and say, well, we're not going to focus on high level figures. But on the flip side, one of the issues with focusing on prosecuting high level figures is it's not always practical. The ICC does not prosecute in absentia. So once it's issued an arrest warrant, it has to wait for that person to be arrested by a state, because it has no police force of its own. It can't just detain people. And then for that state, the arresting state, to hand that person over to the ICC. So it is entirely reliant on state cooperation to really get any prosecutions off the ground. And where that cooperation is not forthcoming, it not only kind of delays the case and kind of ties up all those resources in a case that's not moving, which when you have limited resources is not great. There's a huge amount of crimes that could be tried. And, if your case list is taken up with empty cases, that's not a good use of resources. But also it doesn't do the function of international criminal law and international criminal courts of setting an example of how prosecution can be run. It doesn't encourage confidence in the system. It doesn't encourage kind of the cooperation of states and, more importantly, victims with that system if it's not actually getting them justice. If they issue an arrest warrant and then 20 years later still no one's been arrested, it doesn't give confidence in the system. So there's a really interesting article that was published last year exactly on this, saying that kind of it would be better for the ICC's general function of leading the international criminal law system and inspiring confidence in international institutions if it kind of abandoned that requirement or that ideal of prosecuting big fish and
Yeah.
allowed itself to focus on a few smaller, kind of less influential figures
Yeah.
who they could successfully prosecute
Yeah.
and kind of get that justice done. Because at the end of the day, as we were saying, that's the point of the international criminal justice system, or at least its professed point, to try and get justice for victims and for people affected by atrocities. So, kind of grandstanding is one thing, practical results are another. And there should be a balance between the two.
Yeah.
Um, yeah.
Yeah, true. I think it's often the case that the big fish escape accountability while the small fish
Mm-hmm.
get caught. I think we can see this behavior on the global level, on a local
Yeah.
level, or a national level. I think it's just human problem. My last question is more from the perspective of critical third world approach. So, do you think any of the evidentiary mechanisms within international criminal law address criticism of racism in the international criminal justice system? Because personally, I find international criminal law very clinical in nature, with a strong imprint of Western academic razor style of thinking. And, the whole wisdom of, community justice rooted in the
Mm-hmm.
local land seems to be largely ignored, which I feel the community style of justice is more rehabilitative in nature. Do you agree with this kind of assertion?
I think, yeah, it's an interesting point. I think you've made
Hmm.
kind of two points there.
Hmm.
Um, as regards the evidentiary mechanisms and their ability to address kind of criticisms of racism, which have have been there since the beginning, certainly the beginning of the ICC, and increasingly as it's done its work. The evidentiary mechanisms, I think, can partially address that criticism. Um, the way I think they address it is in that interaction with national legal systems. It's not just about a court in the Netherlands with,
Hmm.
you know, a lot of influence from Western nations putting predominantly Black people on trial. The
Hmm.
evidentiary
Yeah.
mechanisms kind of allow a wider spread of the legal systems involved, the legal concepts involved,
Hmm.
and thereby can start to kind of allow domestic legal systems to take ownership of international criminal law and in that way start to address a balance. Um, that's also true, I think, within the ICC. It's begun to take a lot more account of victims and witnesses, and it's changing its processes a little bit.
Hmm.
Um, however, there's always a however.
Yeah.
Um, if you look at one of the criticisms of racism, it's not just that only African nations are being prosecuted because they're not.
Hmm.
But it's also that when atrocities are being called atrocities, it's not being aimed at things that happen in states like the UK or the US. And
Hmm.
the temporal time frame means that it doesn't apply to previous things that those countries have done. Colonialism, for instance, as far as Western nations are concerned, happened before 2002.
Hmm.
So couldn't fall under the remit of the ICC.
Hmm.
And I think that gets at your second point, which is the framework of international criminal law. It's built in such a way that evidentiary mechanisms couldn't address that racism because it's kind of built into the system
Hmm.
in the way in which it categorizes certain things as being international crimes.
Hmm.
And I think even with something like national capacity building, which supposedly builds domestic legal systems and allows them to take ownership of the ICL, the people training these judges and these prosecutors will take with them their own conceptions of what international criminal law is. And if that is based in kind of a skewed
Hmm.
view of what should count as being the crime of crimes, for
Yeah.
instance, then that will just be proliferated by the national capacity building, which isn't to say national capacity building is bad, just that having it does not fully address the criticism of racism. And also what you were saying about rehabilitative justice and non-retributive models, because the international framework is very retributive. Partially because it kind of has to be, in our conception of it being so abstracted from the community that suffered the harm. It wouldn't make sense for an international system to go in and try and show them a way to rebuild themselves, which would also be patronizing and probably awfully racist in the way it was conceived. But I think there's space for international criminal law to have both. So we saw that with Rwanda, for instance. The criminal tribunal, the International Criminal Tribunal, was retributive in the way it worked. It focused on kind of comparatively few individuals, imposed their conception of international criminal law on those individuals, found them guilty or not guilty, set a punishment. But within Rwanda itself, there were also the Gacaca courts, which were set up as community justice because when they had so many people in prison, and honestly, it's a large proportion of your population who've committed awful things, you can't just lock them all up because your country will stop working. So I think in that space for ICL, as we were saying before, to be broader than just international courts and tribunals, there is room for it to grow and develop into something that is less westernized and can be more suited to the individual contexts in which it functions. And I think, especially with the ICC, the system has the beginnings of something that could be well suited to that, where a state party to the Rome Statute is able and willing to prosecute a case and is doing so. The ICC can't necessarily take that case away from them. So as long as we make sure our interpretation of what able and willing looks like can suit kind of different styles of justice, there is room there for community justice to be built into ICL, and kind of to allow the internationalized system to be a fallback for where something's gone horribly wrong and you need a standardized system so that things are applied equally. But that's not kind of your step one, because standardization doesn't work very well on a planet this large with this many different contexts, and context is key in ICL.
True. I totally agree on this matter that the international mechanisms are only intended to be part of the solution to addressing atrocities. It's one of the ways. And there are many other ways, especially through local justice, to reach better, sustainable, inclusive results. On this note, we conclude our conversation. I thank you for such an insightful, enjoyable conversation. And I learned as a student of international criminal law a lot in this particular podcast. Thank you very much for coming.
Thank you for having me.
Thank you.